Thank you, Mr. Chairman. I want to welcome the Attorney General back to the committee. The work of the Department of Justice touches on some of the most important matters of life in this nation, from fighting crime and terrorism to vindicating our fundamental rights. We ask a lot of the Department of Justice, and we expect a lot. I want to commend you to begin with for recognizing the success that we have had in prosecuting terror suspects in Article III courts. We all want to bring terrorists to justice, and our criminal justice system has been an effective tool in doing so. Until the recent change in administration, that didn't seem to bother my friends on the other side of the aisle. During the Bush years, there were no attempts to tie law enforcement's hands, no opposition to bringing them to trial, no complaints about sending terrorists to jail, no complaints about reading them their Miranda warnings so that we can prosecute them successfully. I hope to hear from you today about the Department's continued use of the state secrets privilege in particular. As you know, I have introduced legislation, along with the Chairman and some others, to formalize and regulate the treatment of the privilege in court in a manner that will both protect bona fide state secrets and that will ensure that individual rights can get vindicated in our courts. In order for the rule of law to have any meaning, individual liberties and rights must be enforceable in our courts. There is an ancient maxim in law that there is no right without a remedy. And if the government violates someone's rights, if it wiretaps your phone without a warrant, if it ransacks your house and steals your guns or your papers, if it invades and ransacks your house, if it kidnaps and tortures you, your only remedy, the only way you have to make the rights guaranteed you in the Bill of Rights, the Second or the Fourth or Fifth Amendments real, is to sue the government for an injunction to stop the action or for damages after the fact. But if the executive can have any case dismissed on the mere incantation of the magic phrase, state secrets, without having to prove to a court that the concerns about revelation of sensitive national security information are real, and not simply an excuse to shield embarrassing or illegal acts or information, then we have no remedy and no rights, and the executive can get away with anything, regardless of anything the laws of the Constitution may say, and no one will ever be the wiser. There can be no law, no rights, and no liberty if the executive can do anything it wants behind an impenetrable wall of secrecy. I am aware and I appreciate that this administration has adopted some rules for the exercise of the privilege, but those rules still reserve unaccountable discretion to the executive without any meaningful judicial review. The guidelines still violate the observation by the Ninth Circuit in the Jepson case that the executive cannot be its own judge, unquote.
Thank you.
That is the key. I'll reserve the balance of, I'll submit the balance of my statement for the record.